Hello, everyone. This is good evening for some and good morning for many. This is the World Arbitration Update. This is our second panel of Asia Day. In Asia, I believe it is the morning. In the Western Hemisphere, it is the evening. Trying to be loyal to the different hourly schedules in the various parts of the globe. We are having this day in accordance with the time in Asia. This panel is incredibly diverse because it brings various systems of law into place, and it also brings various panelists who have various traditions, cultural backgrounds, and this is what we are thankful to have today in the panel related to intersection of special economic zones in Asia and the world. Now, I would like to let you know that this panel, as all the panels of the World Arbitration Update, has as part of its mission, one, decentralizing international arbitration beyond the traditional centers of international arbitration, basically going beyond the Paris and New York and even Washington D.C., going to places in Asia, Hong Kong, Singapore, etc., and various places in Africa and Latin America, as well as other places not usually featured in Europe and even North America. That is one objective. The other objective is to update the international community on issues of international arbitration, international commercial arbitration, and public international law. So with that, I would like to welcome everyone and also welcome our incredible moderator, Professor Julien Chaise, who has been a force behind this panel and has been a force and intense contributor to the making now of World Arbitration Update. Before giving the floor to Professor Chaise, I would like to emphasize that he is currently a professor at the City University of Hong Kong, CDU, School of Law, and that he is an award-winning and well-renowned expert on international economic law, including trade, investment, and tax, cyber law, as well as international dispute resolution. His work has garnered wide recognition and has been cited by international courts and tribunals, as well as the US and European courts. He writes regularly a column on Global Lawyer for the Financial Times, where he actually has discussions on current events in foreign investment law and politics. He is impressively a recipient of the Smith Lowerfield Prize from the International Arbitration Club of New York and has been awarded a Humanities and Social Sciences prestigious fellowship. I would like to stop there, but I know that his research spans not only on trade but also into issues of cyber law and in every respect, he is an extremely curious mind and eager to put into practice his knowledge, which is very appreciative. Julien, I'll stop there. I do not want to embarrass you, but I think it's only fair that people know the caliber of panelists that we have and moderator that we have. So with that, I give you the floor for conducting this orchestra.
Thank you very much, Jose, for this very kind introduction. Very good morning, afternoon, evening to one and all present here. So my name is Julien Chaise, and I'll be giving you the welcoming speech or remarks for today's WOW's panel on special economic zones in Asia and arbitration. So in the next 2-3 minutes of my very short speech, I'll be trying to walk you through what this panel is about, and how useful we hope it can be for you, whether you are attending today, this morning, or whether you watch it later. Well, I think that the theme of this webinar very much reflects the growing recognition of special economic zones in the world economy. If done well, special economic zones are a great vehicle for international trade and foreign investment to drive economic development. It's because I think special economic zones, or simply safe zones, reassure investors and all those exploring business in a particular jurisdiction that the mitigation of risk can be reduced or sometimes even eliminated in a market. So from the proper infrastructures, for instance, seaports and airports, to legal exemptions provided by the host country, or even the alignment with the Western models of regulation, special economic zones have been used as a bridge to encourage and accelerate the development of trade and investment. In fact, some governments are determined to promote business in special economic zones through dispute resolution, relying on sometimes even new technologies. So I think that understanding and explaining the intersection of those zones and arbitration, and how they are used by governments as regulatory sandboxes to attempt harmonizing the legislation that they might introduce on the national level, are central subjects for today's discussion, for this panel. So as in all the WOW panels, we will have a presentation to set the scene, followed by a panel discussion. In a few seconds, Professor Dimitropoulos will make a presentation between 10-12 minutes, providing the context of the main issues of the subject matter of the panel. So it's my pleasure to introduce our first speaker for today. George Dimitropoulos is an associate professor of law and also associate dean for academic affairs at Ahmed bin Khalifa University in Doha, Qatar. I'm very familiar with George's outstanding scholarship, but I cannot list or summarize all his work. In a nutshell, I think it's important to highlight that George's research for many years seeks to expand the boundaries of international economic law and dispute settlement, both thematically and methodologically. So George is already a big star and is well known for using mixed method approaches to unpack the complex relationship between international and domestic law. Of course, George's works has appeared in all top journals, whether in the US, EU, and it had already a deep influence on many other key issues and experts. Let me just finally mention that George co-edited a wonderful special issue in the Journal of International Economic Law on the topic of special economic zones. So quite obviously, WOW made a great choice inviting him. After George's presentation, I will kick off the panel discussion, and we have 5 panelists in that discussion. So we have Pilar Cerón. Welcome. Pilar is currently the managing editor, director, and founding partner of Strategy Business and Investment Center in Colombia and Panama. And I understand that she's the head of Strategy in Miami. I know that Pilar was also part of negotiating investment treaties and FTAs with many countries on behalf of Colombia's government. So it's really great to have her today. Then we will have also Dr. Kehinde Olaoye. So Kehinde is based in Hong Kong. She's a postdoctoral researcher at City University of Hong Kong. Kehinde is also qualified as a solicitor and advocate of the Supreme Court of Nigeria. So she's great because she has worked as a commercial lawyer in Nigeria, and she also worked in an internal law firm in Hong Kong. The third panelist will be Humberto Macias. So Humberto serves as the Chief Executive Officer at the Prospera Arbitration Center, which is the default arbitration services provider of the Prospera Special Economic Zones in Honduras. Humberto also is fascinating because he has very strong connections to Asia, because he was earlier the capital markets attorney in the Singapore office of Clifford Chance. Then we'll have Dominique Dagbanja. So Professor Dagbanja is teaching at the University of Western Australia. He specializes in investment law and the practice of investment treaties and investment treaty arbitration. And last but not the least, we'll have James Losari. So James is a PhD candidate in Hong Kong, but he also has a rich experience in practice. James is experienced in handling disputes relating to cross-border transactions. And he has practiced for many years in Singapore on a wide range of commercial and investment matters. So it will be great to have James' insights on special economic zones for these reasons. Well, I think that's it for now. I thank and welcome our presenter and the 5 panelists who have joined to share their knowledge and experience, and we will ensure that the discussion is grounded in the concrete realities of special economic zones regulation, design, and arbitration. Before coming to a close of these remarks, I'd like to remind you to strictly stick to our time schedule. So it's essentially for George, actually, to really keep the presentation short, so that we have then ample time to have different rounds of questions and answers. So thank you all for your participation. I now hand over the floor to Professor Dimitropoulos. Over to you, George.
Thank you so much, Julian. I'm really super delighted to be here with you, with everybody. I would like to thank Jose Antonio Rivas, as well as Maria Lucia Casas from WOW, as well as obviously you, Julian, for inviting me to join this panel. And I would like to add something to the wonderful remarks you made about myself and my profile. Thank you so much. That, you know, the special issue volume that we've edited, you know, for the Journal of National Economic Law is co-edited, in fact, with Julian. Many thanks, Julian. So what I will be presenting is, in a way, the result of a broader project that Julian and myself have been conducting over the course of the last couple of years. And I would like to provide a kind of a historical as well as a practically grounded approach to special economic zones. This is what I will try to do over the course of the next couple of minutes. And Julian, just, you know, feel free to interrupt me when you know you have to. Okay. So okay. There you go. So this is a little presentation that I've prepared in order to help structure the debate that will follow after my presentation. And I would like to mainly present 2 things, namely, you know, a historical context.
George, this is Jose Antonio. You're speaking very clearly, and I can understand your words. But is there any chance that you could increase your volume just a bit? I'm sorry for the interruption.
For sure. The you know, my voice isn't sounding clear.
It is clear, but the volume may be a little bit low.
So I hope this may be better now.
A little bit better, yes. Thank you.
A little bit better. Okay, I think I will have to keep, you know, the mic a little closer to you know, where I speak. So fantastic. Thank you so much, Jose Antonio. So I would like to give a brief, you know, historical contextual presentation of special economic zones and arbitration, mostly with a focus in Asia, and then, you know, try to give a kind of a broader background between special economic zones, arbitration, and international economic law, as I know is kind of a part of the broader focus of WOW too. So, let me start. Obviously, that, coming from Greece, you in a way have to make a reference to your own country, fortunately or unfortunately. This is Delos, a small, very beautiful island in the Aegean Sea, which, is presented, and, may be true as the first special economic zone that has been ever created. This was created during the Roman Empire, when the Roman Empire, in a way, tried to establish a hub in the Aegean Sea to kind of develop like a strong commercial hub to, in a way, do away with other commercial hubs that used to pre-exist during the ancient Greek times. Now, the story that I would like to present is a combination of three main stories. One of those stories starts really in Delos, but moves on next. It moves on a couple of centuries later to Gdansk or Danzig, and the other cities of the Holy Roman Empire that had in a way detached themselves from the trade relationships of the Holy Roman Empire, and developed a network of cities that started cooperating with each other, and started trading amongst each other. And soon this story starts moving into Asia. And there you go. This is part of the Shenzhen special economic zone, and part of a broader story of development of zones in Asia that, in a way, in modern times, starts with China and the special economic zones that were developed there in the beginning of at the end of the 1970s and the beginning of the 1980s. Now, in a way, the same story moves across to the part of the world where I am currently based, namely the Gulf. And there you go. Some of you may recognize it. That's Dubai. In fact, a special part of Dubai, the Dubai International Financial Center, which is a special economic zone that, in a way, bears a different name and is part of a broader, more recent development of special economic zones that tend to be identified as financial free zones. Okay. Now, here in Qatar, where I'm based in Doha, not far away from where I live, there is another special economic zone called the Qatar Financial Center. This zone is even more peculiar than some of the other zones that I've discussed so far. And, we're going to go into the conversation, if you wish, about the peculiarities of the Qatar Financial Center. It's really worth going into, because the difference of this zone and any other special economic zone is that it is not geographically enclosed, as special economic zones tend to be. Okay. This was, in a way, a part of one strand of a story that I would like to discuss. A second strand of the story that I would like to present to you when it comes to the coexistence between arbitration and special economic zones is an arbitration case, namely the famous or infamous Petroleum Development Trucial Coast case versus Sheikh of Abu Dhabi. This is an arbitration that took place in the 1950s, beginning of the 1950s, 1951, and it was about a concession agreement, petroleum concession agreement between the ruler of Abu Dhabi and a company of British interests, namely Trucial Coast. In that concession agreement between the ruler of Abu Dhabi and Trucial Coast, there was one peculiar clause, namely Article 17, that said that the ruler and the company declare that they base their work in this agreement on goodwill and sincerity of belief, and on the interpretation of this agreement in a fashion consistent with reason. This is the interesting part. Now, a sole arbitrator, Lord Asquith of Bishopstone, had to interpret that clause. And you know what he interestingly and famously or infamously said? Well, this means something. This actually means that I have to apply a law, but the law that I have to apply, I can't find anywhere. Definitely, it won't be Abu Dhabi law, because there is no such a thing back in the day, he said. And it can't be really English law, he said. But you know something? I have to apply a law of reason. And you know what this is? This is actually English law. Why English law? Because this is the closest to a modern law of nature. This is what Lord Asquith of Bishopstone says. Now, the reason that I'm presenting this story to you is because this gave rise and helped shape a whole new series of special economic zones that we tend to find today in the Gulf, but outside the Gulf too, in places such as Kazakhstan. Now, the third story that I would like to share with you is kind of a different story, but I would like to show you how everything converges towards the end of my presentation, namely a story of what would be called deglobalization. Now, it's no secret that both foreign direct investment as well as cross-border trade and commerce have been on the decline in the last couple of years. Obviously, there are many reasons for this, right? But you know, Walden Bello has called it a deglobalization trend. Okay, and we'll see what the role of special economic zones is in this broader context. Now, let us move on to the conversation of the special economic zones. Special economic zones are a fascinating thing. We've been discussing them and, you know, analyzing them and working with them with Juliana as well as other friends. Now, one of the main things that has been happening in special economic zones is are institutional innovations of sorts, and we can then discuss in our Q&A about, you know, how those institutional innovations may be spilling over into the broader, the general jurisdictions of the states that established them. But one institutional innovation that I would like to focus on are international commercial courts. Namely, traditionally speaking, special economic zones used to use arbitration for the settlement of disputes. This has started changing over the last couple of years with the rise of so-called international commercial courts. The special economic zones of the Gulf region, mostly, namely the DIFC in Dubai, the Qatar Financial Center, Abu Dhabi Global Markets, as well as the Astana International Financial Center in Kazakhstan, gave rise to a new institution, what we call international commercial courts. These are specialized courts established within the zone to adjudicate disputes that arise out of the zone. Now, this institutional innovation that actually was developed within special economic zones in Asia has started expanding all over the world. We now tend to find them in other parts of the world, such as Singapore and China, namely outside special economic zones, but in countries that have a rich tradition in special economic zones, as well as, interestingly enough, outside Asia nowadays, in the continent, in Europe, namely in Germany.
It seems that there is a little freeze, so let's hope for George to be able to quickly reconnect. I think we can give him a few seconds for that.
Yes.
If we don't see him reappearing in the next 1 or 2 minutes, I think we should simply start our discussion. As I don't feel to be able to to make George's presentation. Look, I think there may be a technical problem, so the best is really to carry on. So I think, George, as a very short transition before to move on to some questions I'd like to put forward to each of you. Well, I understand that George started with a narrative. He gave us the broad view. So from the start of the SEZ, the second story was the reliance on English or on the common law within certain zone. And I think that the third point was for him to highlight the very fast evolution of the zones, meaning that when we speak about SEZ today, in fact, we tend to speak about different generations. And to make it very clear, I think some of the zones that were established in the 50s or 60s, even if they became very famous, actually remain quite far in terms of structure from the later zones that we observe these days in the Gulf and in many other countries. And I think that's one of the challenges for experts and commentators, because zones do not form a homogeneous category. They are very different. So today we wanted to focus the discussion on the zones in Asia, but of course we can later on slightly broaden the picture. I see George is back just on time to continue the presentation.
I'm terribly sorry, I've never had this before, my internet never failed me before, but, it just, went dead for a second. Would you like me to continue?
Yeah, perhaps, look, George, the best would be for you to resume, but with your conclusion, kind of final remarks that you wanted to do.
For sure. I'm terribly sorry about that,
So, don't worry, it happens.
Right. So as I was saying, zones have given rise to a lot of institutional innovations. In a way, the most important is international commercial courts. Now, the second one is, and I won't be going into the details of this, but we can discuss later during our conversation, is something that has been identified as zone arbitration. Okay, namely arbitration that is specifically done within the zone with institutions that are zone specific and law that is zone specific. I won't be going into the details of that, but we can further discuss during our conversation. Now, how are the three stories that I presented in the beginning converging here? Namely, through something that may be identified, and this is what we did with Julian in our common work, as unilateral economic law. What zones do is, the adding of a layer, okay, of law that may be identified as unilateral economic law alongside international law as well as domestic law as we knew it. Okay, and this layer does two main things. It redefines the relationship between the state and the market. The zones present a very different model on the interaction between the state and the market than what we knew so far. Okay, as well as a very different understanding of space. Okay, in comparison to traditional international economic law that does not look into the background conditions of trade and investment. Okay, so in a way, special economic zones, as well as the arbitral institutions, as well as the international commercial courts that we tend to find there, are a form of what we might maybe identified as institutional deglobalization. While promoting economic globalization, they're at the same time an institution of institutional deglobalization, namely, bring international law home. And let me conclude, Julian, by saying that about the relationship between special economic zones and arbitration, that it can operate in many different ways and at multiple different layers. Special economic zones may be seen as an alternative to arbitration. Special economic zones may be seen as a complement to arbitration, and special economic zones may be seen as partners with arbitration. Okay, namely, you get to find arbitration within the special economic zones, as well as international commercial courts that I presented before have started operating as curial courts for arbitration proceedings. I think I'll leave it at this, and we can take it up in our conversation later. I'm terribly sorry for the technical problem. Thank you so much.
Well, wonderful, George. Thank you for giving us a very insightful presentation. I will have questions to you and for all the others. Just want to remind all those in attendance that they should feel free to use the Zoom chat box to ask questions whenever they want. I'll be keeping an eye on this chat box. Well, I think that many important themes emerged from your presentation, George, which I suggest using to continue the rest of the discussion with our panelists. And I think that the very first theme is the actual impacts of special economic zones in commercial arbitration. I feel it's very interesting to discuss the SEZ challenges and opportunities of tomorrow in this respect. So let me turn to James Lossary. James, aside from generating more advisory, transactional or dispute resolution work for lawyers, do you have a sense of whether or not special economic zones actually bring about a substantive change in the existing rules and the practice of commercial arbitration?
Thank you very much for the question, Julian. I think from my sense, in terms of the changes brought by special economic zones to arbitration, at a very global level, when we are talking about established rules or global or more well-known institutional arbitration rules, I do not see any direct changes brought by special economic zones to these rules. And when I'm talking about these rules, these are antitrust rules or the rules of well-known institutions such as HKIAC, SIC, or LCIA. However, I do notice that there are some indirect influence that's been given by special economic zones, and this could be seen in certain regions and certain jurisdictions, such as in China with the Shanghai pilot free trade zone. I think recently in 2020, there was a decree issued by the by the Shanghai Municipal Bureau of Justice that actually expressly allowed for foreign arbitral institutions to be established and also administer foreign related disputes in the zone. So, which is quite interesting because in the past, when advising clients about choosing which arbitral institutions to do or to resolve their disputes in China, then as lawyers, we are very reluctant to advise them to choose foreign arbitral institutions because there's a lack of clarity on whether the court will actually deem that clause, the dispute resolution clause itself, enforceable. But with these kind of changes, it seems like the Chinese government want to ensure that there are more ways available for foreign investors to resolve their disputes within the zone. And I think George also mentioned about the Dubai International Financial Center that used to have the DIFC Arbitration Institute, which is sort of like the zone arbitrations inspired by the zone itself. And I'm sure in some other jurisdictions, these also exist, but I will leave it to the other speakers to discuss about this. However, I have to say in Southeast Asia itself, we do not see this to develop as rapidly as in other jurisdictions yet.
That's very interesting. I'd like to turn to Kehinde because Kehinde, you are based in Hong Kong. You also worked a lot on Africa, and in fact, much of your research or even practice deals with the relationships between China, Asia, and Africa. I'd like to know what you have seen in terms of actual disputes involving special economic zones and or a number of Chinese investments in Africa. And what do these disputes tell us about the difference between commercial arbitration and investment treaty arbitration and special economic zones?
Thank you very much for your question. So there are two arms to your question. So the first question is what kind of disputes have emerged from special economic zones and parties from Asia and parties from Africa. So I think it will be very important to say at this stage that we don't yet have so many disputes, or the number of disputes seems very small, but it's an area that's growing, and we see there's clear evidence that in the next few years or in the next 10 years, we're going to have more disputes, especially disputes involving Asia and Africa. So for example, there's the DP World dispute with the government of Djibouti, which has been going on for several years. And this has resulted in multiple proceedings. So commercial proceedings in London, proceedings in Hong Kong as well, And also you also have international arbitration, and this is just one set of facts which has resulted in multiple proceedings. But the key thing is, when you look at this dispute, it doesn't necessarily involve, well, it involves an Asian party, so China Merchants, which is sort of the main actor in the dispute, has its offices in Hong Kong. So its offices are in Hong Kong, but it also has a large presence in the mainland, and then also does business in Djibouti. So the choices, you see, but the interesting thing or the fascinating thing is I sort of suspect that the main reason why you have these multiple proceedings going on is because Djibouti, which is also a very key participant in this dispute, has very few international investment agreements. So it has signed maybe roughly 9 or 8 international investment agreements. So when you look at the distinction, here, I think parties want to, explore as many options as possible and ensure that they're able to protect their rights, protect their investments in special economic zones. So the very, very traditional differences between commercial arbitration and international investment arbitration, you think about the applicable law, you think about, the remedies that are available, the basis, of course. So of course, we also find that you have contracts. So concessions, during George's presentation, we heard about concessions, and concessions continue in present times, contracts. And this is, also very, very interesting. But I mean, we can always talk about this later on, but to just round up, I'll just say the key differences, the very, very traditional differences, the applicable law, the types of remedies, the parties. And so lots of differences, but you also have lots of convergences and similarities.
Yeah, thanks, Ken. It's interesting to see how you can comment on the Asian scenario, but your comments, your remarks suggest that we really need to broaden that the view and analysis. And I like to make use of Humberto's insights. As I said earlier, Humberto serves as the Chief Executive Officer of the Prospera Arbitration Center. I think many of you might have heard about Prospera, which is a leading special economic zone in Honduras, where a number of really cutting-edge developments are taking place. Humberto, I think it would be great to know from you what you see as Honduras Prospera Incorporated and Prospera ZDE. What do you think are their relevance to the topic of SEZs in Asia and beyond, and arbitration? How do you see things from your practical perspective?
Great, Julian. Thank you very much for your question. So just for those of you that haven't heard about the work that we're doing in Honduras, there is a legal framework called, it's the Zeta regime. So there's zones for employment and economic development. What they try to do is they try to create a legal space where you can import the international best practices. And within that regime, you can create different jurisdictions beneath that. So the company that I work for is Honduras Prosper Inc. And it's the developer of multiple of these zones. But basically our umbrella zone is called Prosper Zeta. And one thing I think the relation, there's a couple of dimensions to the relationship, but I think an initial one is that I can confirm to you that the world is looking to Asia for the international best practices. So that I know that at the level of the Zeta regime, when you look at the actual law that was created, they used as the basic template, they actually used the basic law of Hong Kong. So that was actually the first draft, is actually what they used for our regime. They also looked at places they did, and also we did at the Prosper level, but like they permit the adoption of common law. So what we did when we created our jurisdiction is we looked at Asia and we looked at the development. And, I think it's pretty clear now that when you're developing a special economic zone, using English and the common law is a best practice. Started with Hong Kong and then Singapore and then Dubai, and then, then you get Abu Dhabi, then you get Astana, so it just became an international best practice. That's also something that we've adopted. So in our jurisdiction, what we've done is we have multiple zones within the country, but our initial one is in the Caribbean. So it's on an island called Roatan. What we did is, instead of just the Spanish that's being used in Honduras. Ours is bilingual. Our zone is bilingual, so it's English and Spanish. We've also adopted the common law, and what we have is default arbitration. So basically, most disputes are actually resolved by arbitration, and they are heard by the Prosper Arbitration Center, of which I'm the CEO. So I think that's one. I think one thing is because of the wide space, there's a lot of innovation that we're focusing on. Like for example, if you Google what we do and you Google Central America and Bitcoin, you'll realize that we're actually one of the spaces here in Central America that's been crypto friendly. So I actually just came back from a presentation, and it was one of the architects that actually designed the Bitcoin city. And he was here giving a speech in Honduras. And he was interested in what we're doing because of these different aspects. And then I think the other one is what we're trying to do is create a node in Latin America for investment. So basically to connect it to the rest of the world. And if you look at what we're doing here, we're replicating what was done in places like Singapore and Dubai, so that we become a node, and anybody in the world that wants to invest in Latin America could do so through us with rules that they're familiar with. And anybody that wants to invest from Latin America to the world can also use us as the gateway. So I think even though we're based in Honduras, I think those are some of the connections to Asian SEZs and also arbitration.
That's very interesting, Humberto. It also shows how advanced Prospera is and the great potential it carries, I think. You might well become a model for many others soon. But it's also good to see that, as you said, Asia was a very important source of inspiration.
Yeah.
I'd like to get back to George, because George has done some research on Asia and the great diversity of the zones in this region. And I'd like to know whether George can share his views on diversity. Are there any discernible types of special economic zones that, say, are more endemic to certain regions of the continent than others? And perhaps a quick short follow-up question, which would be whether special economic zone whether they use different sets of dispute settlement mechanisms. So it's a kind of clarification on what you had said a little earlier.
For sure. Thank you so much, Julian, for the wonderful questions. When it comes to the first question, are there any different types of zones discernible across Asia and beyond? Now, traditionally speaking, there have been two main types of zones, okay? The so-called transshipment zones. You bring goods from abroad, you place them in the zone, right? And then, you carry them over to a different place. The second type of zone that was really, in a way, invented in East Asia, not only China, but also Taiwan, as well as elsewhere, Korea, of course, and elsewhere, are so-called export processing zones, namely, zones that are really dedicated to manufacturing, right? Now, those two types of zones all over Asia, both in the Gulf as well as in East and Southeast Asia, have developed into free ports, right? As well as broader zones that deal with goods. And we get to see nowadays Hainan port, right, which is a large area that is much broader than a port. It's in fact a city. And China seems to be revolutionizing this type of zone. Now, a second main type of zone that we get to see more recently are so-called financial free zones. And these have been developed, in West Asia, starting with Dubai, the Dubai International Financial Center, then Qatar Financial Center, then the Abu Dhabi Global Markets. And then, it moved up a little north from the Gulf, namely Central Asia and the Astana International Financial Center. This is a very new type of zone. Now, a third newer main type of a zone is something that, you referred to this before, and we heard Humberto discuss about this, namely new digital zones, right? Now we move back to Southeast Asia for those, namely Malaysia, China itself, as well as, collaborative zones between Malaysia and Singapore. And it looks like, Singapore is looking to expand this type of a zone elsewhere as well. Now, what types of dispute settlement mechanisms do these zones use? Traditionally speaking, arbitration, right, has been the main way of resolving disputes in zones. And we heard also again from Humberto, the wonderful work they are doing there. Now, international commercial courts are the new way of resolving disputes in zones, especially the type of financial free zone, right, such as the one that we're seeing develop here. I would like to highlight one additional point, namely that in Qatar, we don't only have a financial free zone, namely the Qatar Financial Center, but many more zones, amongst which, a more traditional type of zone, namely the Qatar Free Zones with the Qatar Free Zone Authority. What has recently happened, namely less than a year ago, is subject the disputes arising out of that zone, which is a more traditional zone for that matter, to the Qatar International Commercial Court and Dispute Resolution Center. This is a kind of a revolution that has been happening here. I can leave it at this, but let me highlight, Julian, that this new special type of zone arbitration, right, started expanding all over the world more recently. James made mention to that. Briefly, the four characteristics of zone arbitration are zone-specific institutions, zone-specific rules, the potential of establishment of foreign arbitral institutions, as well as the plurality of ways to arbitrate within the zone. There are obviously back and forths between, those two, between, traditional and non-traditional ways of arbitrating within the zone. For example, and James mentioned that, there is no collaboration anymore between the DIFC and the London International Court, right? As most of us will know here. But Shenzhen, seems to be working towards that direction. China Pilot Free Zone 2, as well as the Abu Dhabi Global Markets. Thank you. Mike, your mic, Julian.
I was saying that the comments on these four features is very interesting and really helps to make sense of what's happening and the potential of each of the zones that are being established. Now, there is a recurring issue in the world of arbitration, which is the one of cost. In Hong Kong, whenever I discuss with some practitioners, and the question is, but what's the main issue that the practice of Hong Kong arbitration is facing? Is the answer is, well, cost all the time. So I'd like to ask Dominic his views on that with the cost of arbitration and perhaps even awards. Pose any challenge to the promotion of business in special economic zones and can become an obstacle to the developments on the mid or long term. What do you think, Dominic?
Thank you very much, Julian, for this question. I think overall, if we look at the cost of investment treaty arbitration in particular, which we can see that disputes involving the zones are settled not just using international commercial arbitration, but also investment treaty arbitration. And I think my sister Olaoye referenced that. Now, so if we look at the cost of arbitration, investment treaty arbitration generally, we can certainly see that it poses a great challenge to the capacity of states to be able to use this mechanism to resolve disputes that arise within that sector. And we can cite the case of Yuko against Russia as an example, where over $50 billion were awarded against Russia. So essentially that can collapse an entire economy. So in addition to the cost of the proceedings, because states will have to pay for the lawyers and those who manage institutions that manage the dispute settlement mechanisms. In addition to that, states have to pay awards, which, as I've said, can run into millions, if not billions of dollars. And apart from the Russian case, the UK's against Russia case, we also have the recent case of an arbitration claim that was brought against Nigeria, and about $55,700,000 were awarded against Nigeria. And I believe that that will become a very huge burden to the Nigerian economy. And that was supposed to be an investment in the zones. And so if you assess the cost of investment treaty arbitration, and that was an investment treaty case, if you assess the cost of the investment treaty arbitration against the objects underlying the setup of the zones, you realize that the cost of investment arbitration, both in terms of payment to the lawyers, in terms of payment of awards, they can really pose a very serious challenge to the capacity of states to be able to run and manage the zones in a manner that will bring the designed objectives for setting up those zones. But also in relation to cost, which is not necessarily directly arising from the dispute settlement mechanism, is what do states lose in terms of the policy cost? That is, they design the zones and give various exemptions, including tax exemptions. And there is often not an assessment of what states lose in terms of what they give out in order to attract investors into the sector. So there's cost here in terms of arbitration proceedings, cost here in terms of the awards that they have to pay, and cost here in terms of what states can lose ultimately in terms of what they give out to attract investors into the sector. And there's a need to assess all of these if zones are really to achieve their intended objectives. Thank you.
Well, your answer, Dominic, is very interesting, also because it helps us to move into the discussion of zones and investments, in investment arbitration, right?
Yes.
So when you look at the world of investments and the number of states that have been dealing with foreign investments in their zones, what are the sorts of policy and regulatory actions in special economic zones that have been challenged in arbitration, in investment arbitration? What do you see there?
Right, thank you. That's an interesting question, and it allows me, as you said, to build on the point that I made earlier on. So there are quite a number of cases involved, and I will refer briefly to some of them. There is, for example, the MTD against Chile, and this case involved the contractor was awarded a contract to develop structures in a planned community. And then after the commencement of work, the government issued a stop order on the basis that the project was not in accordance with the zoning plan in the sector. The investor brought a claim against, a Malaysian investor actually brought a claim against Chile, claiming breach of the fair and equitable treatment standard and other provisions of the bid. Ultimately, the arbitration tribunal, investment treaty arbitration tribunal, decided in favor of the investor on the basis that the government was not consistent with the way it went about issuing a permit for the project to commence, only to turn around to say that the project had not complied with zoning requirement in the sector. There is also the case of Guedes against Burundi, which was also investment in precious metals. And what the government did was subsequently to withdraw the exemptions that were granted in the sector, and the investor brought a claim under an investment treaty against Burundi and ultimately succeeded. They sought to settle the claim ultimately. And then there's also a case of Middle East cement, where a claim was brought against Egypt. Again, in this case too, the government subsequently sought to enact a new legislation that essentially stopped the investor from being able to continue with the construction of projects that were granted in the zone. And then, of course, a last case that I would like to refer to would be the Zhongshan against Nigeria. This was also a case where there was an investment in an industrial park, a zone that was created by the Nigerian government. And the government claimed certain misrepresentations on the part of the investor and ultimately terminated the project. And some of the officers got arrested and detained, and their work permits were withdrawn and all of that. The investor brought a claim against Nigeria under the China-Nigeria bilateral investment treaty and succeeded. And then the $55 million were awarded against Nigeria. So all of these cases point to situations where there is a subsequent, at least in some of them, there is a subsequent change in the government's regulatory framework around the zones. And of course, in some of the cases, we can argue that maybe the states didn't act consistently, but subsequent change in policy in the zones are some of the areas that are likely to be the subject of investment treaty arbitration. And that means that the hands of states can actually be tied when it comes to regulating investment in this sector. Thank you.
Well, I think a very important point is that SEZs are special territory within a given jurisdiction, but whatever is done or undone in this SEZ in terms of regulation is subject to international economic law. I think that was a major point made by George earlier, and it's very, very important that you, Dominic, now insist on the relevance of investment treaties for the design of special economic zones. But since we speak about investments, I think we cannot neglect the role of contracts. And on this question, I'd like to turn back to Humberto and Pilar, because from the myriad types of contracts that investors enter with special economic zone managers or administrators, I'm thinking here about lease or purchase agreements, stability and operative contracts, or stability agreements. What do you think are the role that ADR play as a key element that foreign investors consider for, say, one, the establishment of the investments, and two, the settlement of disputes arising out of these contracts?
Julian, thank you so much. I think this is quite an interesting question. And here is important to note the different measures that investors may want to opt as a means to protect their investments under special economic zones. So I think this is the rationale behind the last two questions that you have addressed. The first one that Dominic has referred already to, with the cases he mentioned, relates definitely to public policies, right, enacted by host governments that may prejudice their property and that may trigger investor-state cases under treaty law within dispute settlement chapters, including definitely investment arbitration. Whereas the question you're bringing now fits within private contracts, like lease agreement or purchase or supply contracts that investors sign in light of the daily operation they are working on, since they are operating from a special economic zone. So that may also affect investment, their interests on those special economic zones. In one case, we are in the field of public law, and in the other case, we are definitely on the arena of private law. So in other words, the possibility for investors to resort to investment arbitration or commercial arbitration, which is basically the topics that we were covering before. However, there's one common denominator, if you have noted here, and is the inclusion and use of international arbitration, the figure of international arbitration on both set of rules, to guarantee precisely not only investors' rights, but also the investment climate. And that basically has to do with the possibilities that investors has or analyze as factors for the investment on those special economic zones or in any different jurisdiction or market. And this is basically what any investor established in any special economic zone is looking to protect. And at the core of this protection for these investors that are established in these special economic zones is the figure of international arbitration. And I won't be surprised that investors, I mean, we on a day-to-day basis work with different investors throughout different jurisdictions and markets. And we are all the time working as well with investment promotion agencies and working with special economic zones that work sometimes as little or mini investment promotion agencies. So we are all the time, you know, like feeling the temperature of these investors to come and establish on these special economic zones. And we ask them, what is the main driver for you to come and to invest in these special economic zones? And of course, they are going to be mentioning the tax regime, the different incentives they have, the different types of special economic zones. But it is definitely a criteria for them to make that decision is the use of dispute settlement mechanisms. And within those methods of investment of dispute settlement resolutions is definitely investment arbitration. So this is how important the figure of international arbitration is taking more importance now, day by day, for investors establishing these zones.
Thank you, Pilar. Yeah, I think there is many things happening in this area of investor-state arbitration with a contract-based or treaty-based, and it would be good to have a better understanding of the the trends in this regard. So I'd like to turn to James and know whether James could share with us some of the data, statistics, or main trends, key features of these main trends that we observe in SEZ-related investment arbitration.
I think there are quite many SEZ-related investment arbitration disputes in the last couple of years. In fact, I remember from 3 or 4 years ago, I was handling one of the investment disputes, but this relates to an Asian state where basically the investor, we were representing the investor in that particular case, an automotive company, a global automotive company investing in the Asian state based on the government's incentives provided in the economic zone, that is fiscal incentives in the form of VAT refund for any sale of the cars which were exported from the region. So what happened in that particular case was that the government suddenly, after a period of time, decided to stop paying the fiscal incentives. And they were not denying the obligation to pay the fiscal incentives, but they were saying that we had some financial issues, so we need time. But then that time required actually extended to a very long period, 2 to 3 years. And for a company, a global company, relying a lot on the VAT incentives when they made the investments, this actually met a lot of commitments. So eventually the case was actually settled. But what I want to emphasize is the trend that we are seeing is that as what Pilar mentioned, when we are talking about special economic zones, it's all about incentives that actually attract a lot of foreign investors. And Dominic also pointed out the change in the policy of the government is always the one that will eventually lead to investor-state disputes. And if we look at how broadly investment agreements are worded, and especially the fair and equitable treatment, any kind of change of policy could potentially fall under that breach of the fair and equitable treatment clause. Of course, provided that you establish that there is a legitimate expectations, it was reasonable, and there was a commitment provided by the government. So we do see a lot of cases arising lately. While there are, it's not necessarily all cases related to special economic zones, but I think given the nature of special economic zones, I'm not surprised that there will be more cases which are relevant to this specific topic in the future.
Yeah, I wouldn't be surprised either. I think the the key message is not so much what are the rules or the reforms that can be conducted in the zones, but how these reforms changes are made. This is this how which regularly trigger cases which involve the fair and equitable treatment, and that's why I would share your views on that. There is a case that was earlier mentioned by Dominic, a very interesting case, the case involving this Chinese investor called Zongshan Fucheng versus Nigeria. I think maybe the latest SEZ related investment arbitration decided over the past weeks. I think would be good to get more insights about this case. Can I ask Kehinde if it's something that she has been following among the many China-Africa economic interactions? Kehinde, what do you think are the key lessons of this latest case dealing with special economic zone?
Thank you for your question. Absolutely. I think this is a very, very important case in, well, as far as investment treaty arbitration is concerned. It's, well, I won't describe it as groundbreaking, but it's a precedent. Why? You know, for many reasons. One, it's the first investment treaty claim between a Chinese foreign investor and an African state. And this is very important when you look at the statistics, because of around over 5,000 SEZs, almost 4,000 or over 4,000 of these SEZs are in Asia. So this is really important. But at the same time, we also have an increase in Chinese-backed overseas SEZs. So you have SEZs being exported in Asia and in Africa. And these SEZs are usually managed by Chinese investors. And this is, of course, based on the fact that we've had relatively successful SEZs in Asia and within China. So this is, you know, from the policy end, but from the legal perspective, the award is very, very important because it establishes some very, very key facts and recurring legal issues. So issues like, one, attribution, issues like damages, of course, and then the fork in the road clause, the fact that we see lots of recurring disputes. So within one dispute, and the parties pursuing commercial arbitration, pursuing proceedings in domestic court as well. But I would just like to, you know, speak specifically about attribution. So in this case, the host, you know, the host state, which is the federal government of Nigeria, has 36 states. And the foreign investor was investing in one of those 36 states, which is a regional government. So it is a sub-regional government with its own government, with its own, you know, well, I mean, with its own executive. And it was the executive in the sub-regional state that was responsible for the activities which led to the dispute. So on the one hand, you have the federal government, which really doesn't know what is going on at the sub-regional level. However, the respondent is the federal government. And so this is the unique thing about international investment law. Because of the way international investment treaties are drafted and because of the way jurisprudence has evolved, sub-regional governments will be responsible, well, are taken as part of the federal government. So the federal government will be responsible for the activities of state organs, including the police, including courts, including, you know, even investment promotion agencies. So this was, you know, it's one of the key things that emerges from this dispute. And it's very important because it's related to the way SEZs are managed and organized. Lots of stakeholders are usually involved. You have investment promotion agencies, you have immigration, you know, You also have tax authorities. So a lot of things are going on, and the challenge for states will be how to coordinate all these agencies and ensure that whatever is going on at the central government level is also coordinated, well coordinated at the sub-regional level.
Well, thanks. I think we began to receive questions, which I'm going to arrange for the last round of Q&A. But Kehinde, I'd like to stay with you just for, perhaps a last comment on what's happening in the world of investment arbitration in SEZ. In terms of, quantity, how many SEZ-related arbitration are in Asia, for instance, and how does it compare? And I think it's quite important. How does it compare with the total number of publicly known SEZ-related arbitration claims? Is it a lot, a little? How do you see that?
Thank you. So of course, the caveat is publicly known. So as we all know, some awards will remain confidential. But when you look at, the total numbers, we have roughly 24 to 25 disputes. Now, the key thing is some of these disputes are, recurring disputes. So for example, the Goetz versus Burundi resulted in 2 disputes. You have Ampal versus Egypt. You also have, some disputes which have resulted in 1 or 3. But when you look at this and you narrow it down, roughly 10 of these disputes have involved an Asian foreign investor or an Asian host state. So this is very, very significant. And I think it matches with the data on the number of SEZs in Asia compared with the total number of SEZs we have around the world.
Thanks. Yeah, it's very useful to know. I think we have around 15, 17 minutes left, and so I'll try to put in the last round of questions a number of different matters, issues, or even cases, plus a few questions that I received from the participants. And I remind that all those in attendance that they should feel free to use the chat box to ask questions until the end of the panel. Perhaps as a first question dealing with the trends and ongoing developments, I'd like to ask Pilar or Humberto, what are the main similarities and the main differences between the FTZ schemes in Asia and what they see in Latam, and how do these impact arbitration as a means to settle potential conflicts arising from the implementation of FTZ agreements?
Sure, Julian. Well, I would say definitely similarities. I would start with similarities. I mean, the structure is quite similar in both regions. I mean, the tax incentives, the various types of special economic zones that are the use of data and IT systems in customs control. But for sure, the most important similarity is the use of these special economic zones as the main driver for economic development of these regions. I would say that's the main similarity and the common denominator, that both regions have used of used these special economic zones as drivers for the economic growth. On the contrary, I mean, the differences that you may find is that right now we see a trend in Asia, special economic zones, tend to be focused more on e-commerce, electronics, and definitely technology transfer, distribution centers, and scientific parks. However, in Latin America, we are more focused on warehousing and logistics, industrial production, and there are a different variety of free trade zones as manufacture and recovery of industrialized products. We definitely want to shift and to, drive more our energy towards these specific services zones. And there are some cases, definitely in Latin America, as Uruguay and Costa Rica, definitely some specific cities in Colombia are targeting this specific free trade zones and technological parks. And well, the case of international arbitration as a means to resolve the conflicts arising out of any potential disputes of these investors within these free trade zones are at the core of the different considerations that investors may have, whether to take a decision or make a decision now that we are witnessing the nearshoring phenomena. And that most of the different fabrics are now relocating from Asia to Latin America. If you survey these investors that are making these decisions to relocate from Asia to Latin America or to the Americas, let's say Miami or any other jurisdiction in the Americas, for sure they will take into account the different means of, or the use of alternative methods of resolution that they will have in order for them to make the decision whether or not to relocate to the Americas, to be closer to the center of production of these products or services, that for sure.
And it's super interesting. In terms of trend, there is another issue that we haven't discussed so far. We understand that investments, treaties or commercial contracts and the associated dispute resolution mechanism may have an impact, do have an impact on special economic zones. But I'd like to ask Dominique about the other way around. What's the impact of what we are seeing, these many disputes, on the design and on the implementation of special economic zones? Are these norms, treaties, contracts, are the disputes leading policymakers to change the way they approach the design and implementation in special economic zones? You are muted, Dominique.
Yes, sorry about that. Yes, so as it became clear from all of the presentations, special economic zones come with a package of benefits, promises to foreign investors, traders, and so forth. And so those promises may become a basis on which states can actually be sued. And I have looked at, for example, the World Investment Report 2019, which says that China has had or established about 156 high-tech development zones. And that came with a set of promises and guarantees to investors in that sector. And I've also looked at the Indian Special Economic Zones Act of 2005, which also provides for a number of packages for traders, investors into the specified areas. So these, are specific programs, guarantees designed to attract investors into the sector. And to the extent that investors, traders rely on them to make investment, these promises could be susceptible to investment treaty claims, specifically the fair and equitable treatment standard, which requires that there be a very stable legal environment for investment. And so the question is, how will states present their promises such that they don't become susceptible to investment treaty claims, especially the fair and equitable treatment standard? But again, there's also the question of how the objectives underlying special economic zones may conflict with investment treaty requirements, such as prohibition against performance requirements, which states will usually want to impose because they want to achieve certain specific goals. And I think the imposition of performance requirements becomes particularly appropriate in the context of special economic zones, which are designed because states want to achieve certain specific development objectives. So again, that could become a conflict with investment treaty provisions relating to prohibition against performance requirements. So that raises a challenge about the sort of promises that states will want to make, and they need to qualify them in a manner that in circumstances where there is a need for change, they can actually make those changes without necessarily being successfully challenged in investment treaty arbitration. But again, it means that if they want to impose certain specific requirements on investors, traders, to make certain specific contributions to the development of the special economic zones, then there is a need to reconsider whether provisions such as prohibition against performance requirements can actually be agreed to under investment treaties. Otherwise, the design objectives really for setting up those zones will be difficult to be realized. Thank you.
That's great. So we had the impact of the law on the special economic zones, the impact of the SEZ on commercial investment arbitration, the impact of these practices and trends on the design of SEZ themselves. I think towards the end of our discussion, it's important to get back to the broader picture, which is at the end, do these zones have an impact on the broader jurisdiction, on the way the law is being made, applied, and so on. And I think it would be great to get back to George on that point, to see whether you have any insights as for what's been the experience on the spillover between special economic zones and the general jurisdictions of the states that decided early on to introduce them.
Thank you, Julian. I believe this is a very important point, because how do zones operate, right? The idea of each and every state that establishes them is that we have a general jurisdiction and we create an island, right? Usually geographically secluded and definitely legally secluded from the rest of the jurisdiction of a country, right? Now, when they're doing so, are they doing this in order to attract only trade investment in that specific, legal island, or do they go on to go beyond that? Now, experience shows, and as in a way the description of our panel suggests, that they have been using, most of the states have been using zones in order to experiment for changes at the general jurisdiction level too. Now, this happens, number one, at the economic level. And there are many examples here. The two prime examples that I would like to highlight are, number one, China experimenting with its free trade zones, especially of the newer type, by using negative lists of sectors for investment, right? Which eventually spilled over into the general investment law of the country, right? That has been in force for 2 years now, if I'm not mistaken. Now, another aspect is the use of UNCITRAL rules of arbitration that has been experimented very often within the zones. And the Dubai International Financial Center is one such example where, the UNCITRAL rules of arbitration were initially used within the zone and eventually, carried over into the general jurisdiction of, the general arbitration law in the United Arab Emirates. Now, that's, one area of spillovers, namely, the purely economic area. But let me highlight another very important area, the non-economic sectors, which were where we're seeing, big changes in the general jurisdiction based on changes that have been taken place within the special economic zone level. And that's, in employment-related matters. The Qatar Financial Center and the broader jurisdiction of the state of Qatar is one such example, among many, many others, whereby the employment law regime within the special economic zone was more favorable to the employees than, the law of the general jurisdiction. And the changes that have happened within the special economic zone, the Qatar Financial Center, in a way are gradually being implemented in the broader jurisdiction. And in fact, the leadership of the Qatar Financial Center has played a crucial role in bringing about the changes in the general jurisdiction. And arbitral institutions, as well as international commercial courts, have played a very important role here, and kind of allowing for these spillovers to happen.
Thanks, George. I think we have 4 minutes left, and so for the very last minutes, I like to do a bit like if I were Larry King, my TV show with my guests, asking you very simple questions and get you very quick and simple feedback on them. So I'm going to ask 2 very simple questions to each of you, and I will answer to answer very, very quickly. Look, from where you stand, how do you feel about the relationship between law, arbitration, and special economic zones? Are you more excited than not in terms of practice, negotiations, transactions for the coming years? Perhaps let's start with Humberto.
I'm very excited because I think the way, one thing that you see in Latin America is that it tends to go to extremes from left and right. And when you use arbitration, contractual arbitration, but also investment treaty arbitration, you can create a very solid structure that makes it very hard to interfere with later. So I think from our end, viewing it from Latin America, I think this is very exciting because it gives a lot of stability in a region not known for stability.
Thanks, Humberto. That's great. Dominic.
Yeah, I think that special economic zones allow states to be able to design and tailor their package for attracting investment into sectors that they believe serve the needs of a specific states. So to that extent, I think it is a very important mechanism for investment attraction and protection. But the challenge here is that it comes as special promises, which potentially, as I said, could become the basis for states to make investors to make claims against them. The challenge is how to reconcile the very special nature of this sector for investment attraction, for national investment, for national development, with the very huge cost that is associated with investment arbitration. And that is a challenge that academics, scholars, policymakers need to engage. Thank you.
Good. And Dominic is very cautiously optimistic, as you can tell, which is good. Hinde, your turn.
Very optimistic, and I think this is definitely an area to watch. So lots of work for academics, lots of work for lawyers as well. I definitely think that we're going to have more cases in the near future.
Noted. James, I just follow the order on my screen. I apologize. You might not have the same order on your own screen. James, yeah.
Sure. I think hearing from what George and Humberto has explained about how the potential development to the legal development contribution from the special economic zones, it really makes me think that it is actually a very exciting opportunity, especially for Indonesia, where I come from. Our arbitration law, for example, is aged from like 1999, and it hasn't been renewed until now, and there are many issues. So if special economic zones can eventually push for this kind of development, it will be very exciting for sure.
Thanks, James. That's Pilar's turn. Sorry, Pilar, you are muted. You have to unmute yourself.
Sorry. Julian, that the traditional relationship was or used to be between economy and special economic zones, but now definitely the relationship between law and special economic zone is one relationship that is getting more and more traction. That I can see it, and it's definitely a matter, or if it's a criteria or a factor that more investors are taking into account for the establishment, for the promotion, and for the operation of their interests in these special economic zones.
Thank you, Pilar. George.
Thank you, Julian. Look, the truth of the matter is that special economic zones in the past have made a name for themselves that was not that good, right? when it comes to employment-related issues, right, and so on and so forth. But I do believe, and I do hope, and for that, I'm super excited myself, that special economic zones are becoming really agents of good, and for the improvement of both economic as well as non-economic type of relationships in the jurisdictions that establish them, very broadly speaking, as well as for the reshaping of international as well as international economic law for the better.
Thank you, George. That's really great. Look, and the very last question for today will be the most difficult one, actually. But this is where I need a very short answer. What's one adjective each of you would choose to describe the future of arbitration and special economic zone in Asia, and in fact, much beyond, because we have seen that the debate cannot be limited to Asia. And so we'll follow this order: Humberto, Dominic, Ihinde, James, Pilar, and George. Humberto, you are the first.
I'd say innovation.
Great. Dominic.
I'm not sure whether I can have the word, but essentially, it should be embracing.
Nice. Ihinde.
Next frontier next frontier.
It's not an adjective, but okay, I take it. Next frontier. James.
Dynamic.
Nice. Okay, Pilar.
Undoubtedly, international arbitration is the recently rising star, I would say.
Very nice. George.
And let me add collaborative.
Wonderful. I mean, we get very good adjectives or terms to describe what's happening in the world of SEZ and arbitration. Look, it's time to come to a close. I think we are perfectly on time. I think it's been a wonderful panel, a great presentation to start, and more than 1 hour of debate and discussion. So excellent. I truly enjoyed this panel. I think we could go on for an extra 2, 3, 4 hours, but we can't, or we have to hope for Jose Antonio to let us do this next year. Let's see. So I'd like to thank again our speakers for the very interesting and stimulating contributions and sharing these wonderful insights from different parts of the world. Thanks also to the participants for the valuable discussions today, and for those who will be watching the video later on. So it's time to close this WOW panel webinar, and I hand over to Jose Antonio, perhaps for a few final words. Thank you.